Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Getting served with divorce papers is a tough, emotional experience, and figuring out how to respond on your own can feel overwhelming. This video will walk you through the basic steps of how to respond to divorce papers without an attorney. First, a very important disclaimer: I am not an attorney and this is not legal advice. This information is for educational purposes only. Divorce laws vary by state and your situation is unique, so consulting with a qualified attorney, even for a single session, is always the best course of action. The very first thing you need to do is not panic. Take a deep breath and carefully read every single page you were given. You'll likely have a summons and a petition for dissolution of marriage or a complaint for divorce. The petition or complaint is the document where your spouse outlines what they want in the divorce, like property division, child custody, and support. Pay close attention to every numbered paragraph. Next, find the summons. This document is critical because it officially notifies you of the lawsuit and, most importantly, it tells you your deadline to respond. This is usually 20 or 30 days, but it varies by state. Do not miss this deadline. If you do, the court can issue a default judgment, which means your spouse could get everything they asked for without you having any say. Your main task is to prepare a formal response, typically called an answer. You can usually find the official forms for free on your state or county court's website. Search for terms like divorce answer form or response to dissolution petition plus the name of your state. When you fill out the answer, you will go through the petition paragraph by paragraph. For each numbered statement your spouse made, you will typically respond by stating that you admit, deny, or lack sufficient information to either admit or deny. Be honest and careful, as this is a legal document. Your answer is also where you can state what you want to happen in the divorce. Once you've completed the form, you need to file it with the court and serve it to your spouse. Make at least 2 copies of your completed answer. Take the original and the copies to the court clerk's office in the courthouse listed on the papers. You will have to pay a filing fee, but if you have a low income, you can ask for a fee waiver form. The clerk will stamp your original and copies, keeping the original for the court record. Finally, you must serve a copy of your filed answer on your spouse or their attorney. This means you have to formally deliver it according to your state's rules. You usually cannot just hand it to them yourself. Common methods include sending it by certified mail or having another adult who is not involved in the case deliver it for you. Check your court's website for the specific rules on service. This process is complicated, especially if you have children or significant assets, so again, seeking legal help from a local attorney or a legal aid society is highly recommended. Thank you so much for watching. If this video helped you understand the process a little better, please give it a thumbs up and consider subscribing to the channel for more helpful guides.